Okay, in the role of corporate counsel on page 961 of Corporations, chapter 13 in Shareholder Suits, reading Bell Atlantic Court versus Bolger. This is 1993 in the Third Circuit, U.S. Court of Appeals. Sharika gave the opinion. The Pennsylvania Attorney General sued Bell Atlantic, alleging it had defrauded consumers. After some initial skirmishing, Bell Atlantic settled the matter, $40 million in customer rebates, making contributions to a consumer education trust, and reimbursing the legal costs of the Attorney General. Following the settlement of the government suit, the derivative suit was filed seeking to recoup from the Bell Atlantic directors the sums paid to consumers and the Attorney General. The derivative suit plaintiff alleged that the misconduct prompting the state's action was a result of mismanagement and a breach of fiduciary duties to the corporation. Bell Atlantic Board appointed a special litigation committee that, after a thorough investigation, opined that the suit was not in Bell Atlantic's best interest. The derivative suit was ultimately settled on the eve of the trial. Proposed settlement required Bell Atlantic to establish and follow new procedures to monitor sales and marketing programs and to pay plaintiff counsel fees in the amount not to exceed $450,000. Seymour Lazar, a Bell Atlantic shareholder, objected to the settlement. The district court approved the settlement. Though Lazar did not formally seek to intervene in derivative action, the Third Circuit nevertheless held Lazar had standing to appeal the district court's approval of the settlement. Although he didn't formally seek to intervene in the derivative action, he still had standing. That's peculiar, but that's how we got to the appellate level. Lazar, spelled differently, impugns the settlement agreement as resulting from conflicts of interest. He attacks Desher, Price, and Rhodes' joint representation of Bell Atlantic, nominal defendant but real party in interest, and the individual defendants. The district court found no disqualifying conflict, relying on Otis and Co. versus Pennsylvania Railroad Company of 1944, affirmed per curiam in 1946, and Hornsby v. Lohmeyer of 1950. Both cases rejected plaintiffs' challenges to counsel's dual representation of corporate and individual defendants. So that's the holding on the counter argument about the dual representation. Not sure why that's an issue. More recent cases perceive problems with this form of dual representation. For example, Messing v. FDI of 1977. So, where was I? Involved a derivative action charging certain inside directors in a merger with fraud, which resulted in their being overcompensated for stock they owned in the acquired corporation. The outside directors were charged with negligence in connection with this merger. The same counsel initially represented the corporation, two of the outside directors, and all the inside directors. Messing observed, some courts have allowed directors in their corporation to be represented by the same counsel in cases that do not involve any allegations of breach of confidence or trust or fraud. Yet Messing nonetheless found that, irrespective of the allegation against the director, be it fraud or negligence, the interests of the two will always be diverse. Messing required the corporation to retain independent counsel other than the attorney who represented the individual defendants. Other courts have required independent counsel where directors are alleged to have defrauded the corporation. See Cannon v. U.S. Acoustics Co. 1975, affirmed in relevant part per curiam. District Court disqualified counsel from simultaneously representing the corporation and the individual directors accused of fraud, conflict of interest among defendants, and risk that confidences obtained from one client would be used against another. Lewis versus Schaefer Stores Co., New York, 1963. Corporation could not share counsel with individual directors accused of defrauding the corporation. Thus, as a general matter, the case law is not uniform on the issue of joint representation of the corporation and individual defendants. Commentators are more certain. In a representative observation, one commentator said, there is some conflict as to the propriety of an attorney or law firm simultaneously representing a corporation and its officers and directors in a stockholders' derivative action, but the modern view is that it is generally improper due to conflict of interest for counsel to attempt to represent the corporation on whose behalf the action has been instituted, while also representing the individuals charged with harming the corporation for their wrongful conduct. William M. Fletcher, Encyclopedia of the Law of Private Corporations. See also Harry G. Henn and John R. Alexander, Laws of Corporations. But these commentators recognize that even under the modern rule, independent counsel may not be required, and the derivative claim is obviously or patently frivolous. If the derivative claim is obviously or patently frivolous. The ethical standards imposed upon attorneys in federal court are a matter of federal law. County of Suffolk versus Long Island Lighting Company, New York, 1989, affirmed in 1990. We look to the model rules of professional conduct to furnish the appropriate ethical standard. And they're citing under Rule 1.13a, a lawyer's obligation runs to the entity. The commentary to Rule 1.13 provides, the question can arise whether counsel for the organization may defend a derivative action. The proposition that the organization is a lawyer's client does not alone resolve the issue. Most derivative actions are a normal incident of an organization's affairs to be defended by the organization's lawyer like any other suit. However, if the claim involves serious charges of wrongdoing by those in control of the organization, conflict may arise between the lawyer's duty to the organization and the lawyer's relationship with the board. In those circumstances, Rule 1.7 governs who should represent the directors in the organization. American Bar Association's Annotated Model Rules of Professional Conduct, Second Edition, 1982. We believe serious charges of wrongdoing have not been leveled against the individual defendants. We say this because plaintiffs have alleged only mismanagement, a breach of fiduciary duty of care, but we do not understand plaintiffs to have accused defendants of breaching their duty of loyalty, which requires a director to act in good faith and an honest belief that actions taken is in the corporation's best interest. There are no allegations of self-dealing, stealing, fraud, intentional misconduct, conflicts of interest, or usurpation of corporate opportunities by defendant directors. So this is a factor. Mismanagement. So less than mismanagement might be okay for dual representation. Indeed, the district court found the directors act in good faith in investigating plaintiffs' demands. As noted, Bell Atlantic's board charged a special committee along with independent counsel to investigate the shareholder plaintiffs' demands. A special committee and independent counsel found prosecution of these demands not in Bell Atlantic's interest. This suggests a relative, though not complete, convergence of individual and corporate interests in defending and settling the litigation. I must highlight here that it is, I think, a material fact that the special committee consisted of independent counsel, even though they haven't got into that yet. Although not dispositive, it is important that early in the litigation, independent counsel, after undertaking an exhaustive investigation, determined the corporation's interests were more in line with those of the defendants and plaintiffs. Of greater significance, however, is the absence of allegations of fraud, intentional misconduct, or self-dealing. We have no hesitation in holding that, except in patently frivolous cases, allegations of directors' fraud, intentional misconduct, or self-dealing require separate counsel. We recognize that corporate law has, so this is kind of a rule. We recognize that corporate law has traditionally distinguished between breach of duty of care and breach of duty of loyalty, the latter being more grave. See Delaware Code annotated Section 8, 102, Charter. So Title 8, Section 102, Charter Amendment provision allowed to limit director liability for breaches of duty of care, but such provision shall not limit the liability of a director for any breach of the director's duty of loyalty. But drawing the line between breaches of care and loyalty may be difficult in many cases. See Frank H. Easterbrook and Daniel R. Fischel, The Economic Structure of Corporate Law. Ultimately, though, there is no sharp line between the duty of care and the duty of loyalty. We do not believe the district court abuses discretion in allowing common counsel here. We note, however, that in cases where the line is blurred between duties of care and loyalty, the better practice is to obtain separate counsel for individual and corporate defendants. If separate counsel, so that's the end of that case. And I'm just going to keep on reading through the next notes because they're kind of long. I can go into the next section before we get to the next case. That makes sense. So if separate counsel is ordered for the corporation and the real defendants, who should be required to obtain new counsel? If the court believes it is the corporation who should retain new counsel, who hires that counsel? Assuming, as is frequently the case, the senior management are the suit's defendants. Who does the corporation's counsel advise on? For example, whether to accept settlement offered by the real defendants. Recall that state indemnification statutes set forth procedural steps and substantive standards for indemnifying officers and directors. Does the same lawyer representing both the corporation and the director or officer pose a threat, opportunity of circumventing these procedural steps and substantive standards for awarding indemnification? Independent of the question of dual representation, can the counsel representing the corporation question the suit's plaintiff as an adequate representative, raise the failure to make a demand on the board, question whether plaintiff meets the contemporaneous ownership requirement, enter a defense on the substantive defense on the merits? Those are all questions. Should the latter be guided by the same considerations that Bell Atlantic and other courts have relied upon for determining when the same counsel can represent the real and nominal defendants? See Otis versus Pennsylvania Railroad. Corporation allowed to answer derivative suit complaint alleging mismanagement by directors and officers by their adherence to long-followed practice for placing bonds without competitive bidding. Notes on problems concerning the law governing lawyers and derivative actions. 1. Attorney conflicts of interest in derivative litigation. Garner versus Wolfenbarger, partly because of their complex four-party structure involving nominal plaintiffs, entrepreneurial attorneys, the corporation, and defendants who in their director or officer capacities have or share control of the corporation. Derivative actions present a number of severe problems that fall under the heading of the law governing lawyers. On one side of the case, there may be a conflict between the interests of the shareholders as a class, who are the ultimate beneficiaries of a derivative action, and the interests of the entrepreneurial attorney who brings the action. On the other side, the interests of the corporation may diverge from the interests of defendants who control the corporation. And the corporation's lawyers may, as a practical matter, regard themselves as working for the latter. Against this background, problems may also arise concerning the lawyer-client and work product privileges. In doctrinal terms, the issue can be phrased in terms of whether the corporation's attorney can assert the privilege in a a way that favors the defendants, even though at least nominally, oh my gosh, the attorney's client was not the defendants, but rather the corporation in whose right the action is brought. In substantive terms, the issue can be phrased as whether which one of the following rules best serves the interests of the shareholder owners. 1, the rule that gives inviolate protection to management communications with lawyers on the ground that to do so will make managers more secure in seeking advice from corporate counsel. 2, a rule that permits exceptions when the very issue is whether the manager's conduct injured rather than served the corporation by whom the attorney was retained or employed. In Garner vs. Wolf, Guy, Barger, 1970, denied. The court attempted to balance the various interests involved by adopting a rule that in the derivative action, invocation of the attorney-client privilege was subject to the right of the plaintiff shareholders to show good cause why the privilege should not be invoked. It is urged that disclosure is injurious to both the corporation and the attorney. Corporate management must manage. It has the duty to do so and requires the tools to do so. Part of the managerial task is to seek legal counsel when desirable, and obviously, management refers that it confer with counsel without the risk of having the communications revealed at the instance of one or more dissatisfied stockholders. The managerial preference is a rational one because it is difficult to envision the management of any sizable corporation pleasing all of its stockholders all of the time, and management desires protection from those who might second guess or even harass in matters purely of judgment. But in assessing management assertions of injury to the corporation, it must be borne in mind that management does not manage for itself and that the beneficiaries of an action are stockholders. Conceptualistic phrases describing the corporation as an entity separate from its stockholders are not useful tools of analysis. They serve only to obscure the fact that management has duties which run to the benefit ultimately of stockholders. For example, it is difficult to rationally defend the assertion of the privilege if all or substantially all stockholders desire to inquire into the attorney's communications with the corporate representatives who have only nominal ownership interests. It's crazy. Or even none at all. There may be reasonable differences over the manner of characterizing in legal terminology the duties of management and over the extent to which corporate management is less of a fiduciary than the common law trustee. There may be many situations in which the corporate entity or its management or both. Moving on. Have interests. Okay, we're still talking about roles of this corporate counsel. Have interests adverse to those of some or all stockholders, but when all is said and done, management is not managing for itself. In summary, we say this: the attorney-client privilege still has viability for the corporate client. The corporation is not barred from asserting it merely because those demanding information enjoy the status of stockholders. But where the corporation is in suit against its stockholders on charges of acting inimical to stockholder interests, protection of those interests as well as those of the corporation and of the public require that the availability of the privilege be subject to the right of stockholders to show cause why it should not be invoked in the particular instance. There are many indicia that may contribute to the decision of presence or absence of good cause, among them the number of shareholders and the percentage of stock they represent, the bona fides of the shareholders, the nature of the shareholders' claim, and whether it is obviously colorable, the apparent necessity or desirability of the shareholders having the information and the availability of it from other sources, whether if the shareholders' claim is of wrongful action by the corporation, it is of action criminal or illegal but not criminal, or of doubtful legality, whether the communication related to past or to prospective actions, whether the communication is of advice concerning the litigation itself, the extent to which the communication is identified versus the extent to which the shareholders are blindly fishing, the risk of revelation of trade secrets or other information in whose confidentiality the corporation has an interest for independent reasons. The court can freely use in-camera inspection or oral examination and freely avail itself of protective orders, a familiar device to preserve confidentiality in trade secret and other cases where the impact of revelation may be as great as in revealing a communication with counsel. On remand, the district court held that a lawyer-client privilege was inapplicable under the standards Garner set out. Garner versus Wolfenberger, 1972, Alabama. The Delaware Supreme Court in Walmart Stores, Inc. versus this is definitely a trade union? Yeah, it's definitely a union. Electric workers. In 2014, applied the Garner Doctrine to permit a shareholder to review certain internal files that concern what Walmart directors knew regarding claims executives had paid bribes to facilitate business in Mexico. The shareholder document request was pursuant to shareholders' inspection rights under Section 220 of the Delaware statute. Delaware previously had invoked Garner only in dicta. There is a split among the circuits concerning whether the Garner principle is applicable to shareholder class actions. Compare Wheel versus Investment Indicators Research and Management, the Ninth Circuit, 1981. Garner is not applicable to class actions in California. But before, I guess Delaware has invoked Garner in class actions. Because this Walmart 2014 case, I think, is a class. It's actually a shareholder derivative suit, which might be a class action. Didn't read it yet. Might be coming out. All right. So with Ward versus Succession of Freeman in the Fifth Circuit, cert denied. Garner is applicable to class actions in the Fifth Circuit. I don't even know what that is. So they're taking the Delaware state. Faust versus White, Sixth Circuit, cert denied. Same. Garner is applicable to class actions. Upjohn. In Upjohn Co. versus United States of 1981, Upjohn's independent accountant discovered that an Upjohn subsidiary had made improper payments to secure foreign government business. After consultation among Upjohn's general counsel, outside counsel, and chairman of the board, it was decided the company would conduct an internal investigation of possible payment. As part of this investigation, the attorneys prepared a letter containing a questionnaire to which all foreign general and area managers over the chairman's signature sent to over the chairman's signature. Subsequently, the IRS issued a summons demanding production of certain records, including the questionnaires. The Supreme Court held that the questionnaires were protected from disclosure by attorney-client privilege. Unlike Garner, Upjohn involved an action by a third party against a corporation rather than a derivative action on the corporation's behalf against some of its managers. So I don't know if the point that they're trying to make here is about dual representation or if the point they're trying to make here in Upjohn is about attorney-client privilege, but we're about to enter into a new section about work product. In Re International Systems and Controls Corp. Securities litigation, Fifth Circuit 1982, the court held that the good cause standard of Garner is inapplicable to material governed by work product immunity, that is, material prepared in in anticipation of litigation, as opposed to the communications between managers and counsel in the course of business decision making, which would be protected under ACP. The court said, right, so remember the Fifth Circuit isn't extending Garner. We already knew that. But we knew it as it pertains to class actions. I don't know what kind of action this is when it says in international systems. It's probably a shareholder suit because that's what this chapter is called. The court said the discoverability of the work product in this context is used by the general principle concerning discoverability of work product under FRCP Rule 26b3, which turns on a general principle concerning substantial needs and due hardship tests. Remember that. See, Upjohn, Supra, which I guess cites Cox versus Administrator U.S. Steel and Carnegie, 11th Circuit, 1994. Courts are, however, badly divided on what constitutes the attorney's work product. See United States versus Edelman, 1998. Documents are work product if they are prepared because of anticipated litigation and would not have been prepared in substantially similar form but for the prospect of that litigation. I like that definition. U.S. versus El Paso Co., 5th Circuit, 1982. Document is attorney work product. If the primary motivating purpose behind the creation of the document was to aid in possible future litigation, that is more broad. Some more protection. U.S. versus Textron Inc., 1st Circuit, 2009, and Bank Doctrine extends only to documents prepared for use in possible litigation, and therefore did not extend the attorney's analysis of risks and disallowance by the IRS of client's method of reporting on its tax return certain transactions. ABA Model Rules of Professional Conduct, Rules 1.6, 1.7, and 1.13. So we're getting into all this ethics stuff right now, or we're actually leaving it as we go into a new section. But I fail to see if this section, the purpose, it's titled The Role of Corporate Counsel, but talking about attorney-client privilege, which makes sense, and work product immunity, which makes sense when you're talking about dual representation. So I understand going into the ethics behind it, but I got lost on the issue. American Law Institute Principles of Corporate Governance, Introduction to Part 2, Reporter's Note. I wonder if there's more to get from that. I mean, the note before we enter in a new section. The last case was about indemnification, okay, which is a different section entirely. In this role of corporate counsel, really, I think this is all about dual representation. So the notes are about how that works in derivative actions. Got it. Okay, so we're citing some rule from ALI, Principles of Corporate Governance, Introduction to Part 7, Reporter's Note, and entering Part 9, Deal Litigation and Settlements. Note on Delaware's Antidote for the Epidemic of Deal Litigation. This is on page 968. Section 1 of this chapter set forth startling statistics regarding the high frequency of shareholder suits in connection with M&A deals. Depending on the frequency of shareholder suits in connection, depending on the particular, 70 and 90% of transactions exceeding 100 million are subject to shareholder suit. These people wrote a secondary source article in 2015 examining 3 types of relief flowing from challenged mergers, 1, amendment of the terms. 2, so these are common issues. Disclosure only settlement. And 3, increase in merger consideration. The authors examined transactions involving 453 firms in the 2005 to 13 time period, of which 319 experienced litigation, resulting in 191 instances of some type of remedy. They found that amendment only and disclosure settlements did not have an impact on ultimate shareholder vote, and there is only weak evidence that an increase in consideration impacts shareholder vote. They also tested other variables, finding that transaction value and the position of proxy advisors had significant effect. The authors recommend that state courts should correlative with Santa Fe versus Green, 1977 Super Chapter 11, withdrawal from disclosure-only challenges and thus remit such suits to more experienced and institutionally equipped federal courts under the federal securities law. Disclosure-only settlements have caught the attention of the Delaware Judiciary. Chancellor Bouchard provides a template for closer scrutiny of such settlements with the In Re Trulia Inc. Shareholder litigation, stockholder litigation of 2016 in Delaware. Disclosure settlements are likely to be met with continued disfavor in the future unless the supplemental disclosures address a plainly material misrepresentation or omission, and the subject matter of the proposed release is narrowly circumscribed to encompass nothing more than the disclosure claims and fiduciary duty claims concerning the sale, if the record shows that such claims have been investigated sufficiently. And using the term plainly material, I mean that it should not be a close call that the supplemental information is material, as that term is defined under Delaware law. Where the supplemental information is not material, it may be appropriate for the court to appoint an amicus curiae to assess the court in its evaluation of the alleged benefits of the supplemental disclosures, given the challenges posed by the non-adversarial nature of the typical disclosure settlement hearing. The complaint in Trulia Inc. alleged the directors breached their fiduciary duty in approving a merger with a single bidder that allegedly failed to obtain the highest exchange ratio for the shareholders. Soon after the complaint was filed, opposing counsel reached an agreement in time for several supplemental disclosures to be added to the proxy statement circulated among the shareholders, and proposed settlement also provided the defendants would not oppose a fee request that did not exceed $375,000, and the plaintiff class would broadly release any claims that could conceivably arise from the merger, except such claims that may exist under specified antitrust laws. The merger was ultimately approved by 79.52% of the shares entitled to vote, 99.15% of the votes cast. Following the merger's completion, the parties sought approval of the settlement, which included any other claims that could be brought against the company's directors. Chancellor Bouchard closely examined each of the supplementary disclosures regarding distinct features of the valuation process used by the investment bank in its fairness opinion to the board. He found the supplementary disclosures were not meaningful in light of all the other information the company disclosed regarding the valuation process. He therefore rejected the settlement, thereby leaving the suit where it had started, a bald accusation of breach of fiduciary obligation. Compare In Re Walgreen, rejecting disclosure-only settlement where disclosures were characterized as worthless by the court, that also concluded that class counsel had failed to represent the class fairly and adequately, so that the district court on remand should give serious consideration to either appointing new class counsel or dismissing the suit. But C. Gordon versus Verizon Communications, Inc., and approving a fee award applied the standard whether the settlement was in the best interest of the class and the corporation, and thus awarded a fee, even though disclosure was believed to provide minimal benefit other than exposing the corporation to additional costs of litigation. Of additional interest in Trulia Inc. is that the complaint did not allege that any disclosure violation on the part of directors had occurred. The complaint essentially alleged that directors breached their Revlon duty discussed in Chapter 14 in failing to aggressively shop the firm to obtain the best offer was received for the shareholders. Moreover, the settlement would release all but certain antitrust claims the members may have against anyone arising from the merger. Trulia Inc.'s likely reflects growing cynicism of a deal-related litigation, particularly the seemingly cosmetic recoveries their settlements produce. By way of background, consider that in 1999 and 2000, only 12% of deals produced litigation. In an era, most of the deal litigation not only involved Delaware firms, but also took place in Delaware. They're citing some secondary source from 2012. Suits in that era were consequential because firms that were sued experienced a statistically significant higher incidence of deals that did not close, and litigated deals that closed yielded their shareholders increased returns. Hence, the deal-focused suits in that former era could be seen on the whole as positive. Times have since changed. For example, another secondary source from 2013 reports for deals valued over 100 million, 93% were challenged, with an average of 4.8 lawsuits filed per deal, with a single deal often giving rise to litigation in more than one jurisdiction. Thus, unless we believe the mores within executive suites change, and rapidly, the rapid increase in deal litigation more than likely points toward an abusive process. Yeah, I would say so. In a study of merger litigation in 2016 and 17, another secondary source finds that Trulia Inc. and the wide adoption of forum selection clause bylaw provision that empower a corporation's board of directors to choose which forum a shareholder suit can proceed when the same transaction was spawned in multiple forums, a topic discussed later in this chapter, are associated with an outflow of suits from Delaware, particularly toward federal courts, involving Rule 14A9 disclosure claims. Moreover, awards of fees in the cases also decline while dismissals have increased. So that's oddly everything we're getting into about deal litigation and settlements is just like statistics, kind of on what was already read. The next section is called Plaintiff's Counsel's Fees, and it begins with just citing there's two cases in here quickly before we get to notes. It's citing ALI Principles of Corporate Governance, section 7.17. After those two cases and notes, not very long, there's a security for expenses, one short case, and another note. Last part of this reading will be private ordering and shareholder suits to finish up chapter 13.